Thank you, Mr. Chair.
Thank you, Senator Tulfo. Senator Cheese.
I'm not the author, Mr. Chair, but just some clarifications before we begin, perhaps for the next hearing and for this hearing as well. You mentioned Attorney Gascon. I saw the letter written by the Vice President of DMCI, Mr. Pasha. Attorney Gascon, tama?
Pasio, Your Honor.
Pasha?
Pasio po, Your Honor.
Pasho? He's the Vice President?
Yes, Your Honor.
And he said you are the corporate secretary?
No, Your Honor. I'm the corporate counsel, Your Honor.
You're the corporate counsel.
Yes, Your Honor.
And you said the chairman, with the permission of Senator Tulfo, I used to be a notary, Senator Tulfo. I ceased because the responsibility is huge and I didn't want to get in trouble. May I ask directly, Attorney Gascon, regardless of what you put in your notes, nag-certify ka, pumirma ka. And I will read the acknowledgement. Before me, in this and that jurisdiction on this date, personally appeared the following. Diba? Who presented to me the following IDs and who acknowledged to me that this document consisting of X pages entitled blah is of their free and voluntary act indeed. But the beginning of any acknowledgement is always before me. Personally appeared. Regardless of what you put in your notes, they did not personally appear. They could not because they already passed, as Senator Tulfo pointed out.
Your Honor, there is an acknowledgement part of the agreement, Your Honor, where in fact, in that acknowledgement, I clearly stated that only all those who appeared to me are present. Where in fact, I put it in the last part that please see ID. And all the IDs that only appeared to me are the one who are attached in there, Your Honor. So that's why I maintain that these two persons, when they came to me, because there are so many of them, Your Honor, I think there are 6 of them. And the 2 of them are not present. And then I clearly put it in the last page that please see ID of only those persons who appeared to me, Your Honor.
Sang batas nakalagay yan, attorney? Sorry, I'm not familiar. I also took my oath as a notary. Well, I'm not familiar unless may bagong pinasa ang Korte Suprema na exemption yon sa before me personally appeared. That you can put in your notes that 2 did not and refer to their IDs. May I know the legal basis, if any, so that I may be educated as well?
I just base, Your Honor, on the rules notarial practice that person who appears to you, or you could notarize it on the other persons who appear to you, Your Honor. Those who acknowledge to you that they signed the documents, that is only my basis, Your Honor. So in good faith, Your Honor, when they appeared to me, I clearly stated not only in the acknowledgement portion that these only the persons that appeared to me, but I also put it in my notarial book that these are all the persons that appeared to me. And these 2 persons did not appear to me, Your Honor.
So you're not attesting to the fact that they signed that document, those 2 persons?
Yes, Your Honor.
And yet, you as the corporate counsel facilitated the registration of that document so that a new TCT will be issued in favor of the company you're working for, despite your personal knowledge that 2 of the 6 most likely did not sign voluntarily, willingly, or even were alive at that time. And yet, that document was used to register your ownership over the subject property. Paano nang, if you admitted earlier na hindi nga sila kasama, yung 2 sa 6 hindi kasama, ba't yung ginamit yung dokumento yun para i-register yung interest at pagmamayari ng DMCI property holding? Yes, sir, please.
Your Honor, as I have said before, this document were not prepared by us. It's a pro forma. When we during the time when it was asked us to meet them, I think the 6 person appeared, and then they as far as we're concerned, and together with their counsel during that time, Your Honor, they were assisted by the counsel, and then they signed the documents, Your Honor. And then that's the basis that they submitted to us, and that's the document that we use, Your Honor.
Exactly. You notarized it with the absence of two persons. Apparently, one of them was already dead. And you used that same document in spite of the fact that you didn't see those two persons and you noted in your notarial book na hindi sila nag-appear, you still use that document to register your ownership. That would be a correct narration of facts, sir?
In good faith, yes, Your Honor.
I yield, Senator Tulfo. Just to interject. As a lawyer, even assuming what you're saying is true, na yung isang kapatid lang, yung may adverse judgment na dapat bayaran yung mga manggagawa, may dalawa pang kapatid na may-ari ng lupa, at best, you have a 2/3 inchoate share. And I'm sure you know the definition of what inchoate means,
Your Honor.
which means
It's that it's still undivided, Your Honor.
may parte ka pero hindi mo pwedeng ituro kung alin mismo yung parte mo.
Yes, Your Honor.
That's why I wanted to invite HLURB, Mr. Chairman, because if they're already developing and constructing it without that issue being settled, anong karapatan na lang magdesisyon para sa sarili nila na ituro, sige, dito na kami. Yung 1/3 nyo, kung 1/3 man nga yan, doon na. Second point, Mr. Chairman. Assuming that your theory is that the workers are only entitled to 1/3 of the total property dahil isa lang yung may utang, ang pinangbayad para ma-settle, correct me if I'm wrong later on by the NLRC, ang pinambayad para ma-settle yung kulang-kulang 2 milyong utang na judgment ng NLRC was the entire parcel of land. Number 2, hindi nila ni-redeem after the period of redemption, which they could have done, either by any of the brothers, for that matter. Because remember, this was not a deed of sale executed by the 3 brothers or by 1 brother without the knowledge of the 2 other siblings. This was by virtue of a judgment by the NLRC. Yes, sir, please. Kindly.
Your Honor, in the proceedings of the NLRC, if you were going to review, I think the NLRC levied the award is only portion of the property, but the sheriff levied the whole property, Your Honor. There is a notice in the sheriff sale, if you will notice in the notice of sheriff sale, that they only the subject of the sale is only 2/3, but the sheriff during that time, Your Honor, they levied the whole property, Your Honor.
Sinong may-ari noon at that time? Si Laksina pa.
It was already sold, Your Honor, in 1995. However, the title was not transferred because during that time, Your Honor, I think like Laksina, the sale has append, what you call this, they paid they didn't pay the whole estate tax, Your Honor. So that's why they're being assessed of deficiency tax of the estate tax. So because of that, Your Honor, the sale cannot secure a certificate of registration for the sale, Your Honor, because the BIR is asking that the estate tax should be settled first, Your Honor.
The subject matter of both TCTs under question is 1 parcel of land. Correct me if I'm wrong.
Yes, Your Honor.
If you yourself are admitting that you only have 2/3, and if at all the subject matter of the case only involves 1/3, edi bakit kayo nagkaroon ng titulo at binili nyo yung kabuuang lupa?
No,
Na
Your
hindi
Honor.
nyo naman
No.
kausap yung mga labor.
No, Your Honor. The sale was what you call this? The sale was completed, Your Honor, 1995.
Between you and the Laksinas?
Yes, Your for 1.6, Your Honor. And the seller of that land, Your Honor, are 3. They were included. The registered owner in the land, Your Honor, are three person, Your Honor.
Exactly my point. They sold the land to you in spite and despite the fact that it was already the subject matter of levy and execution by virtue of a decision of the NLRC.
No, Your Honor. During that time, Your Honor, there is still no notice and levy. It was only in 1995, I guess, Your Honor, the levy was only, I forgot the date, Your Honor. So, 2006, I guess.
When was the levy, Attorney Capuno?
2006 or 2007, Your Honor. Sure, Your Honor, but only recent, 1995 was the date of the sale, and only 2006 or 2007, Your Honor, when the levy was annotated in the TCT, Your Honor.
It was on March 15, 2006. A notice of levy was annotated on TCT number 25491 stating that the corresponding share of Honorato Lacsina in the subject property was levied. Boarded.
Yes, Your Honor, that is correct.
And then, please proceed.
And then, Your Honor, after that, we are not, of course, we are not aware that there is a labor case levied, held against the Honorato Lacsina, Your Honor. So it was only in 2007 or 2008, Your Honor, that we discovered that there is a levy. And during that time, because of that, I think one of the counsel of the, during the counsel of the complainant during that time already, what you call this, conveyed their interest to settle. And during that time, Your Honor, we maintain that we are not party to this case. It should be the Lacsina should settle the award to the what you call this, to the workers. But again, Your Honor, since they requested that they want to be paid already and enjoy their victory in the labor case, and in addition to all the backward on all the previous award that they were received, Your Honor, only the 1 point, only this amount was already not been given to them.
One last point, Mr. Chair. I didn't practice labor. I will admit that. I was a litigator, but not in the NLRC. May procedure ba for attachment sa NLRC during the pendency of a case?
Magandang umaga po, Mr.
Meron po ba?
Meron po.
In this case, this property was not attached during the pendency of the case. Pendente lite.
Wala pong ganun. Pagka
Wala ganun?
nagkaroon na po ng finality, saka pa lang po maaaring magkaroon ng execution on that.
Execution yun. But attachment, pendente lite.
Wala pong attachment sa NLRC.
No, walang ginawa dito o walang poder ang NLRC to attach.
Wala po kaming power mag-attach.
That is perhaps, Mr. Chairman, one avenue for remedial legislation because that remedy, meaning for an attachment pendente lite, is available in regular courts but not before the NLRC. Meaning to say, habang pending yung kaso, para mabayaran ka, i-attach mo at i-annotate sa likod ng titulo yung pendency of the case so that buyers such as the MCI would be put on notice that there is such a pending case and that they should be aware and beware that the outcome of the case has not yet been settled. Thank you, sir. That would be all.
Mr. Chair, kung maaari pa pong magdagdag, magandang umaga po mulit sa inyo at sa lahat ng mga nandito ngayon. Siguro po sa kasong ito nakikita, number one po, hindi po namin alam na mayroon pong particular na kaso.
Are you familiar with the case?
Medyo ngayon lang po namin na nababasa na po.
Wala pa kayo sa NLRC na nung...
Wala pa po.
Wala pa.
Wala pa po. Anyway po, yung tungkol po rin sa concern po rin sa, ito po ay isang pruweba kung gaano po kahirap ang execution sa NLRC. Kung mapapansin po natin dito sa kaso pong ito, nagsimula ang kaso ng 1995, natapos po siya ng 2000. Pero po, siguro po in the meantime, wala pong makitang ari-arian ng may-ari ng respondent. Sila Lacsina po rito. Kaya po kinailangan ng sheriff namin na ang gawin ay ipa-levy yung property nung respondent. So nangyari lamang po yung levy 6 years after na po nung 2000 na decision, which is 2006 na po. Pagdating pa po ng 2006, kagaya po sa mga nangyari sa kasong ito, mayroon pong biglang mga dumarating na third-party claimant na nagsasabi na hindi na yung kung sino ang nasa titulo ang may-ari, kung hindi po ibang tao na ang may-ari. So kagaya po nito, ito po ang isa sa mga dahilan kung bakit po napakahirap po na ma-reap nung ating mga manggagawa na nanalo na sa amin yung kanilang napanalunan sa kaso. Makikita rin po natin sa kaso na ito na yun pong Register of Deeds, kahit po na nagkaroon na po ng auction sale ang NLRC at pina-annotate na po sa titulo yung auction sale ng NLRC, kung tama po yung naalala ko sa kaso based po sa discussion, para pong dinisregard ng Register of Deeds yung auction sale ng NLRC and instead, transfer pa po yung title ng diretso sa Taguig Land ba or sa DMCI? So sa Taguig Land, kahit po ang finding na po ng aming arbiter sa NLRC is that bakit 1995 pa nabili, samantalang hindi pa rin po pinatransfer ang titulo. So dinisregard niya po yung third party claim ng DMCI at ng Taguig Land, pero just the same po, hindi po in-honor ng Register of Deeds yung ginawang annotation, yung ginawang auction sale ng NLRC, ng aming sheriff dun sa titulo, at instead ay hindi pa rin po ibinigay sa mga tao yung lupa. So siguro po isa rin po ito sa maaaring matulungan ang aming ahensya para sa aming for execution purposes na yun pong Register of Deeds kung po pwedeng maitask na ituring kami na parang isang regular na korte at hindi lamang po na isang maliit na quasi-judicial agency at questionin pa ang aming ang power ng aming mga sheriff na mag-execute at yung mga ari-arian ng mga respondents ay maaari naming hilahin.
Thank you for
Salamat.
your valuable insights, and we will take that into consideration, and maybe in the near future, we will craft a law, maybe with the assistance of the members of the NLRC.
Maybe sa next hearing,
Yes, Senator.
Mr. Chair, invite natin yung Register of Deeds.
Next hearing.
Yes,
Okay.
sa next hearing.
Comsec, please take note that Senator Tulfo has requested to invite the Register of Deeds of
Yung sinasabi kanina,
Taguig.
of Taguig.
Of Taguig. No?
Pwede po, siguro po pati po yung sa LRA mismo.
LRA mismo.
LRA.
Siguro po.
All right.
Suggestion lang.
Take note of it. You want something? Do you have something to say, Attorney Gascon? Were you raising your hand a while ago before I acknowledged Commissioner Nigdao?
No, Your Honor.
All right. Maybe we si Mr. Lillo, hindi natapos yung iyong
Ayan, Honors, magandang araw po sa ating lahat. Ako po ay nagpapasalamat na ang kasong ito ay nadala dito sa Senado. Sapagkat ito pong kasong ito ay nagsimula pa noong 1996 September. Hanggang ngayon ay wala pa kaming kasiguraduhan na makamit namin yung aming minimiti. Sana naman po magkaroon ng pagbabago sa mga implementasyon ng batas natin. Pagkat kami pong mga manggagawa ay dihadong-dihado sa ngalan ng hustisya. Sapagkat mahigit 26 years na po ito na kasong ito. Hindi po namin malaman kung ano ba talaga ang mangyayari sa amin sapagkat simula pa man sa labor, NLRC, sa LRA, hanggang Court of Appeals, hanggang Supreme Court, lahat po ay naipanalo namin. Pero nung kami po ay inaano namin sa Register of Deeds, kung na-implement yung decision, pabor sa amin, tinanggihan po kami. Wala po kaming napala na di namin maintindihan kung saan ba kami pupunta. Ano bang batas ang pwede nating may ano dito? Para magkaroon ng ngipin yung ano ng labor. Desisyon ng labor.
Mr. Chair, tapos na ba yung budget hearing para sa Register of Deeds? Sarap gisahin to eh. Na ba? Ngayon na lamang.
It's under the DOJ.
Oh, is that right? Okay.
marami pala violations of DMCI according to the Supreme Court. Are you aware of it?
I'm not aware, Your Honor.
In the decision of the third division. I'm sure you're aware of it.
Yeah, we are okay, Your Honor, but we filed an MR to that, Your
The
Honor.
DMCI is accused of forum shopping. Are you aware of it?
Yes, Your Honor, it was in the decision.
Given the foregoing settled doctrines, the court rules that DMCI is guilty of committing forum shopping when it filed a complaint for quieting of title with the RTC and a petition for certiorari before the CA, decision of which is appealed in the present petition. Ba't kayo nag-forum shop?
Baka makachamba.
Dalawa.
Your Honor, we just only, Your Honor, exhausting. Kasi during that time, Your Honor, again, we are willing during that time to settle. But unfortunately, during that time, there are lots of parties who is coming to the MCI. There is one group who is saying that they are already the owner, and there is another group who are saying that they are owner. And then there is another group that saying that they're owner. Where in fact, Your Honor, we are always accommodating them. They always going to the office asking them for us to pay them. But we are explaining to them, if we will going to settle one of you, all parties should appear to us and have an agreement that after this, after we settle, no more claim will be again raised against the MCI. But again, Your Honor, the workers and also the other groups are not agreeing to each other. So we are at loss, Your Honor. Sino yung kakausapin ng DMCI? So that's why, Your Honor, actually, they keep on and changing the lawyers, and then another thing, they will come again to us, and then they saying, "Hey, I'm the owner of the property. There are different parties already. So that's why the MCI, in fairness to us, we want to settle them. But unfortunately, ang dami ho nila. Ang dami ho nila. Ang sabi ho nung isa siya na may-ari. Ang sabi ho nung isa siya na rin ho yung may-ari. Kaya naano po kami, nasabi namin kung magsisettle tayo, we have to make one stand and go to the labor arbiter. We settle everything so that we determine who will be the to settle once and for all this case.
Mr. Chairman, just a clarification because I'm getting confused now. The deed of redemption, correct me if I'm wrong, that you notarized, covers the entire property. Not just 2/3, the entire property.
Yes, Your Honor.
I'm confused now. From day one, you said yung may litigation is only 1/3. Sinabi mo kanina in Kuwait. But when you did the deed of redemption, it covers the entire property. That the TCT you were able to secure covers the entire property as well, which the Supreme Court struck down. Yun, final na yun. Wala nang issue doon, di ba? Correct me if I'm wrong. That's not the first division case. That's the third division case. Is that correct? Ang pinag-aawayan nyo sa first division case, yung pag-nullify ng title nyo ng NLRC, ng labor arbiter, ng NLRC. Yun yung nasa first division. Is that correct? But your claim itself covers the entire property, because if really you're interested only with the 2/3 and you want the laborers to be paid and you're not that nice and magnanimous, then why not sue for partition?
Your
So that
Honor,
the Kuwait share of the laborers can be rightfully given to them.
yeah, I acknowledge that.
Did you ever do that?
Your Honor, during that time, again, the workers during that time are claiming the whole property, which the MCI really objected. We said that we are that the property, that the portion only of the property should be given to the workers. But Your Honor, during that time, they still maintaining, even the other parties maintaining that they want to get the whole property.
Fine. Sila yun. So, purki tinaangkin nila yung buo, angkin nyo na rin yung buo. Because again, your position that they own 1/3 and you only bought 2/3 from the Lasinas was not in the early pleadings, It was not there. That's an afterthought. Siguro napikon na kayo, nainis na kayo sa mga workers kasi ang kulit, kine-claim yung buo, 1/3 lang naman dapat yung kanila, dahil kami na rin. Tao lang, napipikon po, di ba? So, right? But you're claiming the entire property now.
During that time, Your Honor, yes, we're claiming because
Yes.
it is as far
Just a yes or no. You were claiming the entire property from day one up to today?
Your Honor, the portion of the property that not the 1/3 already, Your Honor, we are claiming now because we have already Your Honor, settled with.
But even before settlement, you were claiming the entire property.
Yes, Your Honor, because
That's all. Meaning, so wag mo sabihing 1/3 lang hinahanap. Because if you really wanted only, and if you really understood that you bought only the share of the two siblings and not the one with the case, then you could have sued for partition. And you could have gotten your 2/3. Hindi. You also wanted the whole property. And I'm not, business is business. You want to earn a profit. But don't wash your hands of, we want to help the worker. Hindi. Because if you really wanted to, you could have sued for partition, gotten your 2/3, and given the workers ano. Now, may I ask, how much did you buy the property for? How much was the value of the property in 2006? The whole property, as in the subject property, was never divided into 3 anyway.
I have no in the deed of sale, Your Honor, in 1995, the DMCA only bought the property at around. I am not. I don't remember, Your Honor.
Give me a ballpark figure. I'm sure that's why you were sent here, to answer all of our questions in the absence of your chairman and president. Magkano nyo binili yung property kay Lasinas? The whole property,
30 million, Your Honor.
30 million in
1995, Your Honor.
When was the rescission issued?
No. The NLRC decision po.
Yes.
Oh, yeah.
The award.
I think 2000 po. Tapos 2006 po na.
Yung levy.
Opo.
Yung levy, right?
2006 po yung levy. Pero 2000 po yata nagkaroon ng entry of judgment na fine.
May we see the deed of, can you submit to the committee a copy of the deed of sale? Because in the Supreme Court decision, Mr. Chairman, Senator Tulfo, they said it was not in accordance with human experience that a corporation, a real estate company at that, would fail to register for over a decade a deed of sale covering a huge tract of land. And that decision has since already become final. Would that be correct? Yun ba yung first division or third division? Third division yun, ko naman. Tapos na yun eh.
Your Honor, the one that is filed on MR is the one that says that why the MCI in the how many years didn't register the sale. Again, Your Honor, the reason why we didn't registered it because, Your Honor, during that time, again, the Laksinas, the seller are being assessed of the estate tax, deficiency estate tax. And because the Laksina, during that time, it is the responsibility to what you call this, to process this, to secure the estate tax clearance. But unfortunately, in those long period of time, they didn't secure this clearance, Your Honor.
Sir, that is standard practice too. You could have rescinded the sale if it took them 10 years to pay the estate taxes. Or number 2, you could have simply subtracted it from the purchase price and you paid it yourself to make sure, as it is usually done. Di ba yung capital gains, yung buyer na minsan na nagbabayad para siguradong makakuha kayo ng car sa BIR, mina-minus na lang sa purchase price. In this case, I find it incredible too that DMCI would wait for 10 years, longer than that, because of an estate tax issue, and you could have simply deducted the estate tax from the purchase price that you would be paying to the siblings.
Your Honor, during that time, we have already paid. There is nothing more to deduct from the seller because they are already paid.
That could have been taken into account at that time, because you knew of that already. Ba? Anyway, that's your business judgment.
You still have something to say, Attorney Capuno, or
None from our end, Your Honor.
no more? All right. We will continue hearing this issue by next week, November 29, same time at 10 o'clock. And I would like to take note, I would like to, again, to reiterate to the committee secretary the invitation that should that Senator Escudero has mentioned. May I know who they are again? LRA? Yung CEO ng DMCI?
President CEO.
President and CEO ng DMCI?
Okay.
HLURB? Who else? Okay, PSC, PSE, Philippine Stock Exchange. Can you please tell your president and CEO of the MCI to be available on that date,
Yes, Your Honor.
or else we will issue a subpoena. All right?
Apo. Yeah.
Okay, hearing is hereby suspended
Thank you.
until November 29 at 10 o'clock in the morning.